Okay, great. Okay, I'm gonna put this live.
And after that, I'll make a brief intro and then we'll start.
Okay. We are live and on the record.
Thank you. Good morning and welcome to the Appeals Court oral argument session for October 8th, 2021. We heard the first three cases in the courtroom, but we're hearing two cases now on Zoom. And except for the fact that you're appearing on video and that you can sit down if you want to, we follow the same rules as usual, which is 15 minutes per side, no rebuttal. We ask that when you're not speaking, if you could mute yourselves, but stay on the video so we can know you're there. Being aware that we can still see you, so keep reactions and gestures to a minimum. As you know, we've read your brief, so you can start right in. If we're looking away from you, it's because we're looking at the transcripts of the record materials. We mean no disrespect to you, and we're not paying attention to you, but we're looking at other record materials. So with that, I'll call this case, which is Commonwealth versus Jones, 2020 P643, and attorney, is it Grapple or?
Yes, Your Honor, Grapple.
You have 15 minutes. Once the clock will start going once you start.
Thank you, Your Honors. May it please the court. My name is Joshua Grapple, and I represent Desmond Jones, who appeals the denial of his motion to suppress evidence heard in Brockton District Court. It is perfectly legal in Massachusetts to drive a car for 7 days from the date of registration. Mr. Jones was doing exactly that when he was stopped by the state police for not having an inspection sticker on November 18, 2017. As stated in Terry versus Ohio, it is imperative that the facts be judged against an objective standard. Would the facts available to the officer at the moment of the seizure or the search warrant a man of reasonable caution the belief that the action taken was appropriate? In this case, the Commonwealth did not meet its burden of showing that the stop was supported by reasonable suspicion, where the police for 18 minutes had available in front of them and at their fingertips information confirming that Mr. Jones was legally driving without an inspection sticker.
Can I ask you, one of the issues for me on just exactly what is the timing of this? I mean, the officer testifies that the stop was 8:01, and that's on the, the journal says that, but yeah, we have the CJIS request, which is made at 7:42. Are they, what are they doing during, do we know what they're doing during those 20 minutes?
It is unclear exactly what they're doing. It would be assumed that they were following Mr. Jones while he was driving, but it's unclear exactly what they were doing for those 18 minutes from the time they ran his information in the mobile data terminal until the exact time of the stop.
The way the judge's findings are written, and I don't know if you can say based on this record this is clearly erroneous, is that they start to pull him over, they run as they're doing, but prior to stopping him, they run the report. Is it, how does it, I mean, it seems like it's almost they're doing it as they're driving along right with the blue lights on.
Justice Massing, my understanding from the record is that it was actually his information was run before. It was run at 7:42 p.m. Whereas then the stop occurred at, I think it was 8:01 p.m. So whether or not I don't think that there was testimony the blue lights were on. I think that would have
not. So
in the record too.
It just says prior to stopping the vehicle, Trooper Trout ran the license plate, and then the judge seems to find there are two different screens. There's the screen that he's seeing, according to the judge. Screen number one provided information regarding the car's registration, but later he saw R5.
So I acknowledge that part can be confusing, and it's so because of what Your Honor did just stated, and because he had credited all of the testimony of the police officer, or Trooper Trout, excuse me, who said first that essentially this is when authenticating the records, this is the screen that would have been visible to you when you ran the plate at the time of 7:42 on November 18th. And that's from page 28 of the transcript. And then where Trooper Trout then says, this would have been, yeah, R, and it's an audible screen, yeah. Then testifies to seeing 3 pieces of information, all of which can only be seen at the same time as the registration date. So Trooper Trout says that he saw whether it was registered, when it was inspected, who the registered owner was. And so that is obviously where, if that testimony is credited, does create some confusion, because all that information can only be seen on one screen in the entirety of the records that were admitted. And that's on the what's labeled R5 screen, but the screen, I'm sorry, I didn't mean to.
Oh, no, I'm interrupting you. The judge says later Trout learned after manually clicking another screen. So the judge finds there's 2 different screens. Is that wrong?
It is. I think it is wrong in that it's confusing. We're obviously contesting the error of law here, but it's confusing in that he credits the testimony and then says that it is in the rulings, if what Your Honor is saying, in the presumably after the stop, but it does say manual clicks over to the R5 screen, which is confusing because he testifies to seeing the screen, which is labeled as an R5 screen, and has all this information.
There was no testimony. There was no separate testimony that he manually clicked onto another screen, if I recall.
There was no testimony that he did that. In this case, he manually clicked onto another screen.
But I mean, even if he didn't, your argument is that he should have. That he had an obligation.
Yes, Your Honor. What we're saying is that even if he did not, he had this information readily available, and it was something that could have easily, it was a step that could have easily been taken to steal language from Commonwealth versus Mangret, which we cited in the brief. The ease and speed with which this police officer could have looked at this screen and confirmed whether or not Mr. Jones was driving lawfully or unlawfully without an inspection sticker. This is something that this officer should have done. It would have been easy and obviously less invasive than conducting the traffic stop in this case. And because of that, the action was unreasonable. The stop should be the stop should have been held to have been invalid or unlawful, excuse me.
So so an officer could not do this, according to you. He sees a car driving without an inspection sticker. He can't just pull behind and pull them over without doing any checking. Like
that's what we're saying, Your Honor, is that where the police have at their fingertips a mobile data terminal, something that they rely on, they can verify whether or not this person is driving a car lawfully, especially where, as I mentioned, there's a 7-day grace period in Massachusetts, something that's widely known by almost anyone who owns a car, that you can drive lawfully without an inspection sticker. Where they have this mobile data terminal, they should have reviewed the information to confirm or dispel their suspicion. With respect to sort of what was expected in previous cases, this set of facts was almost exactly anticipated in Commonwealth versus Rivas, which we also again cited in our brief. And it leads us to the inescapable conclusion that the Commonwealth didn't meet its burden of establishing that this stop was lawful. So in that case, it dealt with a red inspection sticker. And while the stop in that case held to be lawful, the court pointed out how close this case was to Commonwealth versus Baez, where they said that where in that case that had to do with window tints, the police officers couldn't be certain as to whether or not the person was driving lawfully. They also said, unless the information is available by computer in the police car, the officer cannot know if in Rivas, the 60-day grace period has expired. So in this case, what we have is the information available by computer in the police car. And therefore, because they had this information, again, available to them, this is what they did is took a very invasive step, curtailing somebody's liberty in order to confirm or dispel their suspicion where it could have been figured out before.
So your position is it was on the first screen that he probably looked at. You point that out by the information the officer testified to, and the only page it could have been on is at R5. And even if he hadn't noticed that it was within the 7-day period, it was there and available, even if he didn't see that screen or just didn't notice it on the screen that was in front of him. And therefore, because it was readily available, even though the judge found that he determined it later, it doesn't matter. That the availability of it and the easily accessible availability requires him to check that before he makes a stop. Is that essentially what you're saying?
That's an accurate description of our position, Mr. Justice Lemire. So, and again, to emphasize or to bring out what Justice Seifer, said in Commonwealth versus Mangret, it's a measure that was easy, that was quick, that could have been taken and would have protected somebody's liberty in this case.
In Mangret, Justice Seifer also says that it was very significant there that it was a mandated policy to do the WMS check right before the arrest. So there's no mandated policy here, right?
There's no mandated policy that was in the record here. No, Your Honor.
Is that an important distinction from Mangret or not?
So we acknowledge that in Mangret, the fact that there was a departmental policy was an important part of Judge Seifer's conclusion, but I don't think that it entirely hinged on the violation of the departmental policy in that case, especially where Judge Seifer cites to Shepard and Hernandez and Sensolo, which we cited in Lobo, where the point that she was trying to make is that it renders the exclusionary rule almost meaningless if the police are allowed to conduct investigations that are more intrusive, or not conduct investigations, but take actions that are more intrusive where they could have easily figured out whether or not the action they were taking is lawful. And I think the fact that it was baked into a departmental policy goes more toward why it's important for the police to conduct these types of checks, whether it's warrant management system, whether it's, in our case, mobile data, checking the mobile data terminal, because it can provide important information, which cuts both ways. It can give them information that shows a person is committing a crime or has a warrant, but it also protects citizens because it dispels suspicion. It shows that they, like in Mangret, went and cleared their warrant in court prior to the arrest. I did also want to point out that it's an unpublished. I understand it's an unpublished case. We're using it for its persuasive value. It's the United States District Court case we cited of United States versus Rowell, or Rowell. I'm not sure the pronunciation, but
it's the Judge Seifer. So, I mean, Sarah's case, right?
I'm sorry.
It's the Judge Sarah's opinion.
That's correct. Your Justice Mason. It's the Sarah's opinion. Almost exact set of facts here. Actually, it was the same amount of time too. It was 2 days prior to the stop. This individual had registered their car, and in that case, again, what Judge Sarah said is the police officer's assessment of the facts was both wrong and unreasonable because the mobile data terminal screen in the cruiser, when read correctly, plainly demonstrated that the defendant was within the 7-day grace period permitted by the registry regulation, and that stop was found to be unlawful even under the Fourth Amendment. So I see that I have 2 minutes here. I also wanted to emphasize sort of the importance of adopting the holding that we put forth in our brief, which is that this also serves to protect citizens from what it serves to do is it prevents the Commonwealth's burden of proving that a stop supported by reasonable suspicion from being lowered. Because otherwise, if you allowing the police to either feign ignorance or disclaim having knowledge that would dispel reasonable suspicion, essentially allows them to ignore facts and take unlawful and intrusive steps against citizenry.
All right. Well, I think we get it. Anything else you got? Anything else you want to say, or?
No, Your Honor. I would just rest on my brief.
There no other questions? Okay. Well, then we'll hear from the Commonwealth.
Thank you, Your Honor.
Thank you. ADA Anderson. It's still good morning, so I can say good morning.
Good morning. Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. The motion judge properly denied the defendant's motion to suppress the evidence and statements where the state troopers had a reasonable suspicion to stop the defendant for a traffic violation when they observed that the defendant was driving without an inspection sticker affixed to his window. When the police have observed a traffic violation, they are warranted in stopping the vehicle.
But in this case, did they necessarily observe a traffic violation?
They observed the traffic violation because there was no sticker on the car.
Right, but there's a theory by which, and in fact it was true in this case, the driver or the car didn't need to be bearing an inspection sticker under these circumstances, right?
Under these circumstances, he did not have to have, had another 5 days to get his sticker. The police did not know that.
But they had that information available to them in the cruiser should they choose to look for it.
And this is where the Commonwealth is disagreeing. The first screen, the officer testified, this first screen that you pull up only has a certain amount of information. It would have whether the car was registered, when it was inspected, it was the owner, and who was the owner. What you have to next do is click over a screen called an R5 screen, which was presented at the motion hearing. In the R5,
oh, sorry, I didn't mean to interrupt you. Go ahead.
In the R5 screen is the screen that has all of the information, the detailed information.
So even assuming that that's true, isn't that screen still available to the police through the mobile data terminal in the car?
It is available to them in the car, but the officer also testified that there are lags of time, that they sometimes just have a long time in between, especially at night. They have a long time in between getting information. And when he was asked this question, he just said, he learned later from the R5 screen that the defendant still had time to get the sticker. But what he knew at that time was reasonable. Everything is based on the reasonableness. It's not a question of a mistake of law or mistake of fact. The question is whether the officer had a reasonable suspicion that a traffic violation was being made.
Right, but
go ahead.
But he didn't, I mean, it would be different if he said, we saw the no inspection sticker and pulled them over and we later ran the plate. They ran the plate. I know he talked about a lag, but he didn't say we didn't have that information in this case. So that information was right there, whether it was on the first screen as opposing counsel suggests, or on another screen, but it was there presumably as minutes, maybe up to 18 minutes or whatever the time was before he made the stop. So doesn't that distinguish it from him just making the stop and not just having the information? The information was on the computer in front of him.
Well, we're saying the information was not on the computer in front of him, and the judge credited the officer's testimony. He's saying on the first screen, he specifically said that type of detailed information is not on the first screen, that you have to go into another screen to get this information. He did not testify that he did or that he did not go into that other screen.
But counsel's argument is also not he actually had the information, but that it was available. In other words, his suggestion is the information was actually on the first screen based on his accumulating the pages from those screens and suggesting that the information was on the first screen. But even if we accept the judge's finding, the fact is, counsel also says, because it was readily available by even flipping to another screen, the stop is invalid.
There was no evidence that the first screen, that the information was on the first screen. There was no evidence.
Counsel submits the copies of the screens as one of the exhibits and points out that the information the officer, it's my recollection the counsel pointed out that the information the officer said he had available is only on that screen, R5. That was my understanding of what he said. In other words, that the information the officer said he saw on the screen, that information is only available on R5.
I really don't remember if he said it was only on R5, but he said it wasn't on the first screen that you received, but that it was on, you click the second screen, and that the screen would be the R5 screen, and that the information is on the screen. That's from what I remember.
Well, that's what the officer said.
That's from what I remember from reading the testimony from what the officer said. And you're saying that, are you saying that this isn't true?
My understanding that counsel, your opposing counsel, has submitted the copies of the screens and said the information that the officer said he saw is only on the R5 screen, which would also include the date of registration, which would then key the officer into knowing that he was in the 7-day grace period.
That's not, I'm sorry, Your Honor, but that's not the way I read the testimony, and that's not the way I tried to read the screens that were submitted. They're very confusing. It's the first time I've seen them. And the only screen I saw that had any type of information was the R5. I didn't really notice the first screen.
All right, so it's your position, even though R5 was one click away on the computer right in front of the officer, he had no obligation to look at it prior to conducting a full stop.
I don't believe that he did have a prior obligation to do that, but we don't know when that screen came up. I mean, he testified, there's lags. It happens often.
Well, he wasn't saying it happened here, though.
He didn't say it happened here. No one asked him if it happened here either. He just said that that it happens often, that there are lags, and that later he saw the R5 screen.
Would it be okay for the officer he sees a car going by without a sticker at all? Would it be okay just to stop it right there without even looking at the screen, without even looking at any screens?
I believe it would be, because there is a possibility that the car, number one, it doesn't have a sticker. Number two, there could be something wrong with the car, and it's to protect the public from equipment that could be damaging. And yes, I do not believe that he had to click on anything, that he had to go through the CJIS, that he could have stopped the car. He had reasonable suspicion right there. I don't know of anything that says before you stop the vehicle, you have to go through CJIS. I think it's CJIS, I believe they call it CJIS. I don't know of anything that says you have to go through that. There's broken taillights, you stop. Headlights, you're stopped. I don't see anything where you say you have to go through the computers and look at this and look at that.
You know, of course, what what might happen then is that he pulls him over, and then, as usually happens before approaching the car, then he runs the query, and then he finds out, oh, I shouldn't have pulled him over. And then what?
Then we have to deal with it.
He goes and approaches.
But I don't think that
I'm
usually
sorry.
happens. But I don't think that usually happens, Your Honor. I mean, this happens thousands of times a day. People are pulled over for headlights, taillights, pulled over for stickers. And as long as the officer has reasonable suspicion, and it's reasonable. I mean, that's the whole key. Is it reasonable to stop the person? And usually, I believe what usually happens is, if the person has 7 days, okay, you have to go get your sticker. And if you don't have your sticker, then you get a citation, or you get a citation for a broken headlight. But I don't believe that you have to go through an investigation, may it be small, to go through and find out this information. And if it's true, as the judge credited, everything he said, the officer said was true. If it's true that you could put information in, and then you have this lag time, and it's not saying how long the lag time in, but he said it could be significant lag time. What are you going to do? Just sit there and just wait and wait and wait, and have the motorist wait for a broken taillight?
Wouldn't the lag time go to what information was available, though? Not that if you checked, wouldn't that argument have more force? I guess is what I'm asking. If the officer had actually checked and there was information that was there, but that was incorrect. That's not the situation here.
I guess I'm still confused with the question, because we still don't know what the lag time was, whether the information would have been correct or not. So I really don't understand the question that well, because it could have been a half hour, it could have been an hour. We don't know. And it could have been information that was bad or information that was good. The lag time would have been the lag time. Are there any other questions, Your Honor?
No, I see none. Thank you both. Really interesting case. And we'll obviously think long and hard and take it under advisement. So thank you both for your arguments.
Commonwealth rests on its brief. Thank you.
Okay, we are live and on the record.
Okay, well, good afternoon, and welcome to the Appeals Court Oral Argument Session for October 8th, 2021. This is our last case we'll be hearing today. I think you're all familiar with how we do this. The attorneys are dividing their time in 7.5 minutes each for the appellant, and then 10 minutes for the department and 5 minutes for the child. Recall, this is an impounded case, so don't use names. It's pretty easy here because there's only one mother, one father, one child. So, we've read the briefs, and Judge Lemire and Judge Hand and Judge Massing are all ready to hear your arguments. So I'll call the case, which is 2021 P202, Department of Children and Families versus Mother and Father.
May it please the court, I am attorney Catherine Foster on behalf of the appellant father in this case. This court reviews as many as 150, I think, child welfare appeals every year that have feature a constellation of parental deficiencies, substance abuse disorder, untreated mental illness, unstable and sanitary housing. None of these issues are present in this case. Leaving the court with the question, what is the parental deficiency? And at the beginning of this case, in September 2017, there was an incident between the parents that led to the child's removal. In response to that, DCF asked father to complete services, which he did find and complete. In addition to what DCF requested of him, he completed anger management, and the couple enrolled in couples counseling together. So the stated concern was domestic violence, but we know that by the time of trial, this was not a great concern for the department, and in fact, somewhat pretextual, because the department had been allowing the parents to visit together since June 2018. And from June 2018 until November 2019, the social worker never had a single concern about the parents' interactions with each other or their child at a visit. In addition to that, the case...
Can I ask you just one quick question here on a factual question? Both of the appellees cite the social worker's testimony based on the report of the previous social worker that your client came into court with a black eye on one occasion and said he was afraid of the mother. Is that when did that happen? Is that supported by the record?
It's not supported by the record. I'll maybe let Mother address that, because she has pointed out that it isn't supported by the record. And also, there was an incident in March 2018 where father came early to a visit, and he asked the then social worker to say that he'd been there for 2 hours, because if not, mother would get mad. And as far as actual record evidence, that's the last kind of indication that the couple was still arguing. As I understand it, was still in the record. So in addition to the visits, the caseworker also testified that DCF's policy is not to allow parents with a concern of domestic violence to visit together, and they did. She also testified that it is normal practice to find out whether or not there's ongoing domestic violence to call police departments. And she testified that she did monthly call multiple police departments in the surrounding communities for mother and father and never found any. So there were no police reports. DCF saw them together weekly and never had a concern. They worked well together in the community. Their anger management counselor, who was at first reluctant to let a couple participate in anger management together, said they were perfect, attentive, and that it worked out very well. So if this father, who was either a perpetrator or a victim years before of domestic violence, did services, no violence happened, and even DCF recognized that it wasn't a problem, then where is the deficiency? In the absence of other evidence, DCF turned to the issue of bonding with the foster parents. But this court has recognized in adoption of RONA that considering the issue of a bond, which is presumed in every case with the foster parents, is not appropriate for termination decisions, because then every case would result in termination. Children bond to the caregivers that they see every single day. Here, the evidence about bonding in particular highlights the argument against the judge's rejection of father's expert, because not only did the judge reject positive probative evidence about father's parenting by rejecting the expert, but the court elevated factors like bonding with the foster parents and her statements in the social worker's car that RONA had said are not relevant to the determination of unfitness. And not only that, but by elevating...
Whose statements in the social worker's car?
The child's.
Okay.
For instance...
Can I go ahead? So you make, didn't the judge have a reasonable basis for preferring the social worker's testimony over your expert's testimony? I mean, that just because your expert's an expert doesn't mean that they're entitled to more deference than any other witness.
That's normally the case. But in this case, not only because of the extreme disparity between the credentials and the reliability and the credibility of the 27-year doctorate and the 1.5-year associate degree caseworker, but also the fact that the the very facts that the judge elevated and then underweighed are facts that are not supposed to be even involved in the calculus of unfitness. And by underweighing and overweighing, she created this sense of comparison between the foster parents and the natural parents. And this court has also said that fitness is not comparative. But when you have the judge saying, recording that the child called her foster parents mommy and daddy, but not recording that she also called her natural parents mommy and daddy, it just seems like a clear issue of a comparison, an inappropriate comparison.
Okay, can I ask you about the point you raised in your brief? You raised the issue of language access in your brief. You cite the Appleseed report and the OCR language access complaint decision. Am I correct? Those were not introduced at trial.
Those specific reports were not introduced at trial, but the issue of language and translation was introduced at trial.
Although, I mean, I noticed there were questions about things being translated and was a translator needed, but in father's counsel's closing argument at the end of the trial doesn't say anything about language being a problem. And in fact, your client also doesn't say, denies language being a problem.
Well, the real tragedy here is the fact that DCF so dramatically failed to fulfill its responsibilities to this limited English proficient client under the law, under regulations, under its compliance order, and then for the court to then also fault the father on the basis of something like not signing his service plan, which was never given to him in English, which he never said he could read English. In fact, at trial, he said he couldn't read English. And it's also
He said he's better speaking than reading. That's what he said, right? Yeah.
Yeah, but even then, proficiency or even functional English is not the same as fluency. And when DCF sees that a parent needs help understanding, this is really important stuff. That's why there's these regulations that DCF is supposed to follow with regard to these clients, because the misunderstandings carry such a horrible outcome.
Okay. Well, I'm gonna have to stop you there unless there's other questions from the other judges. No. Okay. We'll then switch over to Attorney Chayette. Is every single case you get before me, or do you have many more cases and it's just a coincidence?
I've thought of that. No, I do occasionally appear before another judge.
Okay, good.
But yes, I've had the privilege and the pleasure of appearing before you multiple times, Justice Massing. So may it please the court, Kara Chayette for the mother. There are two principles that I'd ask the court to keep in mind. The first is that the term unfit may have moral overtones, excuse me, but the determination whether a parent is unfit is not supposed to be a moral judgment. It's not supposed to be about whether the parent is a good person. The second is that these cases are built on the idea of redemption. DCF removes a child because a parent has grievous deficits, concrete deficits that put the child at grievous risk. And we're going to give the parent the opportunity to redeem themselves by fixing those deficits. Both of those principles were violated here. And my proof draws a little bit on what Attorney Foster just said. This is not a case where we have drug or alcohol use or abuse, mental illness, medical neglect, child abuse, a lack of housing or unsanitary housing, cognitive deficits, special needs of a child. What this case also doesn't have is that parent whose path to redemption is too little too late. How many cases that you hear every year involve a parent who it's like the light bulb went off a month before trial, and that's when they enrolled in the batterers program or the domestic violence class. Here it was just the opposite. We have a mother who immediately started into her services. 5 months after that, she's done with her services. And before any of that, DCF, this case, the child is removed September 2017. April, DCF has already decided to terminate and mother has completed in June. Mother, it's the complete opposite of that ordinary case where mother's criticized because a year and a half later, the following social worker can't confirm services that the mother participated in a year and a half prior. So
Can you walk me
what do
through
you
that?
do?
Can you walk me through that? You say that she did sign releases for the prior social worker, and then what happened with when the new social worker came on?
So she signs releases because we know that because one, you can't confirm participation in services without releases. And the June 2018 21A report, which I do cite in my brief, and I'm sorry, I don't have that cited at my fingertips, but and the judge even finds that yes, the mother participated in her services. She'd done her parenting class. She'd done batter's program. She'd done anger management. She'd done the domestic violence services. So that was completed by June. Baez, Angelica Baez is the original social worker. She has confirmed those. We know that she can't have confirmed without releases. And then in April of 2018, DCF had told the parents that they were going to change the goal. In June, they do that formally. And then Isokin, the new social worker, comes on the case sometime in August. And suddenly there's this manufactured problem of, well, she can't confirm the services that have already been completed. And I'm sorry that I have more cites at my fingertips, Justice Massing, but that's the procedure. And I was going to get to with Isokin, the social worker, among her testimony are questions: did the mother give releases to the other social worker? Do you have the releases from the other social worker? And the social worker says, I don't remember. And then she's asked, have you seen the releases? Well, yes, I did. I mean, it's sort of this whole effort to deny the reality of completed services, no service plan that ever asks the parents or the mother to do any other service. And then it's just, years now go by.
Can I ask you about the CASA? It seems sort of counterintuitive to me in a way that she would be biased against your client when she was actually your client's CASA. What's the bias?
Imagine if she were a lawyer and she was representing the mother, and now she's representing the child in contested litigation at which the mother's rights are at risk. And for the whole life of the CASA's time on this case, her reports reveal that she spoke with the mother exactly once. Her negative assessment of the mother and the mother's engagement with her daughter at visits absolutely is baked into the judge's negative assessment of the mother's fitness, which brings me.
Is that just, I read those too, and and I see you're saying there's sort of like an inherent conflict is what you're saying. Like, you wouldn't even go to whether there's an actual conflict because there's a apparent conflict. But that said, the reports seem to be fairly objective. I mean, that she's saying that mother is just is standing to the side and not engaging.
Well, so let's talk about three things with respect to the visits. The first is this overarching thing. It's the flip of what Attorney Foster was talking about with Rona, that we don't give any particular weight to a child's bond with her foster parents, because that bond is a natural and inevitable consequence of a child being taken into care and placed with a good foster family. The flip of that is that we shouldn't be giving any particular weight to what happens in visits, in this artificial construct of a little DCF room where you're seeing your kid a couple of hours a month, where the kid may not warm up, right? Every single case has the creation of a bond with a foster parent and a disruption of a bond with a parent. As a procedural matter, those facts move a parent closer to termination. But as a matter of evidence, that stuff is inappropriately considered if we're considering a parent's evidence. There's also this willful blindness of a young woman who was 17 when she had her kid. She's in high school. She doesn't have any siblings. It's not like she grew up taking care of her little brother and little sister. And now she's thrown into the situation. Baez's reports of the mother's connection with her child and her capacity to relate with the worker and with her child were quite favorable until the CASA started showing up at every single visit. The expert, even although it was stricken, mother testified that she could hear the CASA making negative comments about her from the doorway. And the expert, although I noted in a footnote that it was stricken, heard it as well. So there was not anything, any love here. But the source of the bad assessments was this social worker who couldn't be trusted, who couldn't even testify, said she didn't remember if she'd ever had a conversation with the mother. And a CASA who should have had no business being anywhere near this case. And the judge had no business relying at all on anything. And I'm 2 seconds. The 800-pound gorilla in this room is the moral distaste that everyone had about the genesis of the relationship that was based on allegations that the judge at finding 44 expressly said, I declined to credit it. But that's the only thing that helps this case snap into focus. And that's a moral judgment. It had no business here. And I'd urge the court to vacate the decree.
Okay, thank you. Guys, I have one more question for you before you, idea of the father and the mother doing joint visits, whose request was that?
What DCF said is, there's testimony, I think it's at page 258. Why did DCF permit joint visits? Because they said they were in a relationship. That's what the social worker said. And then, is it normal for DCF to allow joint visits if there are domestic violence concerns? No. Is it DCF's policy or practice to permit joint visits? No. All of those sites are in the brief. But so it was passed along as, well, they were together, so we let them, which makes zero sense. It makes zero sense.
Thank you.
Thank you.
Okay, I think we're hearing from the department first, and I don't want to mispronounce your name. So how do you say your last name?
Hoke.
Hoke. Attorney Hoke.
May it please the court, Natalie Hoke for the Department of Children and Families. And I'll start out by answering that last question. It was child's attorney's request for the parents to have joint visits. At a report hearing in June 2018, the attorney stated that we all need to face reality. The parents are remaining a couple. They want to parent their child together. So their visits should be together and their services should be together. The department honored that request by the next report hearing, which was a month later.
Thank you.
Every single care and protection case that comes before this court has a tragic backstory, and this case is no exception. However, distrust of the government and the department and a traumatic history does not give the parents in any case a license to neglect their child and subject that child to additional trauma. Ultimately, this case involves a mother and father who, at the time of trial in this case in 2019, on the second care and protection that was filed against their daughter, had not meaningfully engaged in their services that were intended to address the domestic violence in their relationship.
Well, so I mean, I read the record a little differently. It seems like for each of them, they both tried one program that they had that they failed at, but then they each did 3 programs that they succeeded at.
They did participate in services, but they didn't do so meaningfully. Essentially, they showed up and attended their programs, but as evidenced by the record, in which the last incident that I could point to in the record is in August 2018, the new social worker took over, and sometime after that date, father told the social worker directly that he was scared of mother and mother hits him. And then back in March 2018, father came to a visit.
I'm sorry, say that again. That he told the new social worker that?
Yes, so there was
her testimony is that was something that she read in the other social worker's report.
So there was 2 different lines of questioning. The first one was about the black eye, in which the social worker testified that father had told the previous social worker that mother had given him a black eye and he was scared of her. Then sometime, and unfortunately there's no specific date, but we know it's after August 2018, that's when the new social worker took over. Father told that social worker directly that he was scared of mother and mother hits him. And so this was months after both parents had said they had fully engaged in their services and benefited from them. And then there's the March.
Can you tell me that? Can you give me the site on that?
I don't have the site, but I cited to it in my brief.
Is it in the transcript or in an exhibit?
It's in the transcript.
Okay. Go ahead.
And so while the parents did participate in those services, they did not do so meaningfully. And even the participation that they did have in those services, they weren't upfront with a lot of those services about why they were engaging. And for example, the couples counseling, which the parents did take it upon themselves to go to, the therapist reported to the social worker that the therapist didn't know why the parents were attending couples counseling because the parents didn't even tell the therapist. So it's concerning that while the parents are participating in services, and if I just might acknowledge that nowhere in the record does father testify that he didn't know what was being asked of him, that he didn't know what services were being requested because of the language barrier. If anything, father is showing that he did know what was being asked of him and he did go to those programs, but the issue is that he did not meaningfully participate in those programs in any way that mitigated the domestic violence in their relationship or even the anger issues. And that's evidence as mother and father continuing to argue with the social worker, even mother arguing with the social worker in front of the child at one visit, parent-child visit. And so,
can I ask you if we, you know, I hear you saying there was continued evidence of domestic violence or anger, but if we were to strip the finding of domestic, if we were to disagree with that and to strip away the finding of domestic violence, would there be clear and convincing evidence of unfitness?
yes, so the parents were voluntarily absent from visitation with their child, which demonstrates that they were parents of convenience. Father testified that he often didn't attend visits voluntarily when the visits weren't able to be accommodated to his schedule. Right before trial, mother missed almost 3 entire months of visits and refused to explain why. She did not give an explanation to the department. And when asked directly at trial, she refused to explain why. And so
she did offer, she did offer to tell the judge. And the judge said, no, that's not how we do.
Yes, but she refused. To this day, we do not have an explanation of why mother had missed almost 3 months of visits immediately before a trial. And then also the visits mother did attend, while the department does acknowledge that some visits did go well and the parents did engage in some visits, but over 2 years, what the evidence shows is that parents weren't always fully attentive to their child's needs. For example, at one of the visits, mother was told the child has a soiled diaper and that she needed to change her. She left for 5 minutes and came back and said she was changed, but her diaper was still soiled. At another visit, mother was observed to be struggling changing the child's diaper. So while the parents, more father than mother, did interact with the child, their interactions weren't always appropriate and demonstrating that they could care for the child. And for example, as to the child's state of mind, which the court did properly consider with the comments that she made before, during, and after visits and her presentation, she would often tell father, don't take pictures of me, don't hug me, you're not my family. And so that goes, moving on a little bit to the significant bond, and that the court did not abuse its discretion in determining that visitation there did not need to be a visitation order because there was no significant bond. And the court was correct to discredit the expert's conclusion.
I'm sorry, not in terms of visitation, but in terms of the finding of unfitness. Where am I going with this? Did the judge give too much weight to the child's thriving in the foster family, as opposed and doing a comparative thing as opposed to the unfitness of the parents?
I don't believe so. If anything, the judge spent most of the findings on the parents' unfitness. There are findings about the child's interaction with the foster parents and the child's own statements, but the judge did not determine that it was a decisive factor in her decision that the parents' rights should be terminated solely because of that bond. If that was the case, the judge would have needed to make the explicit findings as outlined in Adoption of Catherine, but the judge did not do so, further demonstrating that that was not the decisive factor in this case to terminate the parents' rights.
But the judge had to explicitly say this is the determining factor for me, or can we make an assessment based on our reading of the judge's findings and conclusions where she put her decisive factors.
I think the court could take the findings as they are and also come to that same conclusion, and that there's evidence, there's over 100 findings, I'm forgetting the specific number now, of evidence of the parents' unfitness. So while it would be helpful for the judge to say this is the factor is determinative or not determinative, it isn't needed here based on the other evidence in this case and the multiple other findings that point to unfitness on behalf of the parents.
Can you explain why the failure to re-sign the releases is a problem?
So when the new social worker took over the case, the new social worker needed new releases because releases often expire after a year. And also releases are only usually signed to release information to a specific social worker. So
was there any new information that she needed to get?
Since trial was coming up, it's unclear from the record, but my assessment would be that the social worker needed to follow up to verify that the parents, since the issue is whether they meaningfully engaged, follow up more on that issue. But then also the parents were presenting as a couple and did say that they were attending couples counseling, and the social worker, until she got the releases signed in July, was not able to access that information. And the department, at some of the report hearings, it was brought up multiple times that especially child's attorney in the department was saying that 10 weeks of anger management class wasn't enough, that they needed to go back for more classes, more courses. And obviously the parents disagreed, but it would have been the department's hope that the parents continued to engage in services and hopefully get to a point where they would meaningfully engage and move on from the domestic violence in their life. But the court did find that it was able to rely on past indicators of the domestic violence in the relationship, that even though we don't have a police report before us in 2018, we do have father's own statements, father and mother arguing with the social worker, and even father showing up at court and the translator having to tell the judge, he's so angry, Your Honor, demonstrating that the parents, even though they engaged in domestic violence services and anger management, they did not meaningfully engage by their presentation at trial itself. Well,
I mean, you're under cross-examination, isn't it kind of what the attorney's trying to make you angry? Isn't it sort of a reasonable reaction?
Yeah.
And that was in the course of asking him about the other children and with other women.
And I think that demonstrates an additional point in which the court made multiple findings. I see my time has expired though, so I'll briefly.
No, you give another minute. I get both of the other attorneys had an extra minute. So go ahead.
I just wanted to briefly touch on the inconsistencies in their testimony, as I know mother and father both point to that as a cultural bias. While different cultures, they can be reserved or more open. What was evident here at trial was the parents on multiple occasions contradicted their own testimony and contradicted what they had told others in the past, including the court investigator and the department. So that's not evidence of a cultural bias in the judge's findings. That's evidence that that mother and father were not credible to the court itself. And unless this court has further questions, the department rests on its brief.
Seeing none, we'll give the last word to Attorney Katz, which you usually don't get. You got to unmute yourself.
Can you hear me?
Yes.
Yeah. Thank you, Your Honors. Daniel Katz for the child. First, I want to address, I believe it was Justice Massing's question about where in the record was the evidence that father came to the DC office with a black eye and said that he was scared of mother, and also that he said that mother hits him. Those can be found in the transcript, pages 283 to 284, and then at page 304.
Oh dear, you're we're having a little bit of trouble there.
Do you not hear me?
You froze for a second. I heard 30.
304 is the site for the father coming in to say that the mother hits him, and 283 to 284 in the transcript is the site when he came to the office with the black guy and said that he was scared of mother. 2 days before the child arrived at her new home, Your Honor, when she was only 13 months old, she was soaked in urine and wearing a diaper that was too fit for her. And this is while she was in the care of her biological parents. 3 days before she arrived at her new home where she currently lives. She was placed unsecured in the back seat of a car while the mother drove unlawfully because she did not have a license, was trying to chase the father who was on foot, and the mother drove with her infant biological daughter unsecured in the back seat across front lawns of people's yards, trying to chase the father. Thirdly, when she arrived at her new home, where she has been since she was 13 months old, she was suffering from constipation and in need of early intervention services. Since that time, while she's been in the care of her new foster/pre-adoptive parents, those problems have been resolved. The attorney for mother cites that these cases either are or should be about redemption. I would argue these cases are about the best interest of the child. Why did she drive unlawfully and risk the life of the infant? Why did she not come to visit for 2-3 months? Why did she skip the foster care review the week of September 20th, 2019, because it was not at a convenient time? It's not enough to just say you participate in services. The mother was unable to follow instructions to change the diaper. After being prompted, she was unable to do so. This is what this court should consider namely accepted part of being a parent. When a child soils themselves, you change the diaper. Both parents talk about participation in services, but as I said, your honors know, it's not sufficient to just participate. And let's look at the testimony of the man, the counselor, who went through 10 sessions and 10 sessions, the answers parents gave to the questionnaire. Well, the man who testified, the counselor, was unable to say whether they actually benefited from the services. It's not enough to simply participate. And mother didn't even fully participate. Why did mother, in one anger management class, have her own mother, the maternal grandmother, take her place in the class? Is that looking out for the best interest of one's biological child? Is the father telling the DCF worker that he was scared and that mother hits her, and then not fully completing meaningfully the services? That is not sufficient. Both parents did not disclose to this counselor a history of domestic violence. Father also missed some visits because they were not at a convenient time. And both father and mother also were unable to change the diaper when the child was soiled. That is a basic act that a parent must do to be considered capable and able to demonstrate that they can parent a child. That was absent here. Visits are important. One of the appellant attorneys thinks that the judge put too much emphasis on what happens at the visit. That is not the case. That is not the law. The fact that mother was unable to engage many times, not always, but many times with the child, shows a lack of an ability to parent, despite whether she took some classes or not. There's evidence in the record of police intervention coming because of arguments between the parents. There is evidence.
Attorney Katz, I think I've let you gone over for a while.
Okay.
I'm going to stop you there, but I want to ask you something unusual. You were breaking up a bit, and I'm going to give you the option. You don't have to take it. You know, you can look at this your argument on YouTube, and if you would like to send in just a letter saying what we didn't hear, you know, don't go beyond what you were saying, but just to clarify what you were saying, I think might be helpful to the court. You know, you don't have to, but if you would like to take the opportunity to sort of transcribe your argument, I think you may.
Okay, can I leave you with one last thing?
Yes, one last thing. 15
Okay.
seconds.
Okay.
You really want the last word.
When the social worker, Miss Oz, takes the child back to her foster / pre-adoptive parents' home, the child says, "I'm home." The child is home in her new home. Thank you, Your Honor.
Okay. Thank you all.